I don't mind. I mean, I don't
Well,
mind.
you're not here next week.
This is an open hearing in Court 73 at the Royal Courts of Justice as part of the independent inquiry relating to Afghanistan. The hearing is before Lord Justice Haddon-Cave, the chair of the inquiry. Please could I ask you to ensure that all mobile telephones and other personal electronic devices are either switched off or in silent mode. Please may I also draw your attention to the fact that the chair of the inquiry, the Right Honourable Sir Charles Haddon-Cave, has made a restriction order in relation to the conduct of those who are attending this and future hearings. The full order is displayed on the inquiry website and on the door of this court and of the media annex, but I will summarise its purpose. The order, which applies to this and to all future hearings of the inquiry, prohibits any person from making an audio or video recording of the inquiry proceedings from within the hearing rooms without the express permission of the chair. Furthermore, no person may take a photograph in any room in which inquiry proceedings are taking place and at a time the inquiry is sitting without the express permission of the chair. For the avoidance of doubt, both of these prohibitions extend to the hearing in the media annex. A further part of the order arises as the live stream of these inquiry proceedings via YouTube will purposely be subject to a 10-minute delay. It is prohibited that any person may disclose, publish or broadcast in any form or by any means anything that is said or done in the inquiry hearing room until 10 minutes after it has taken place. If an application is made for a restriction order in relation to anything that has been said or done in the inquiry hearing room in the preceding 10 minutes, anything that was said or done during that period is subject to a restriction order prohibiting its disclosure, repetition or duplication until the chair has finally determined the application. All of the above orders are subject to a penal notice. This means that any breach of any element of the restriction orders may be certified to the High Court or the Court of Session, who will have the power to fine or imprison anyone found to have been in breach of the order. Court rise.
Miss Broom.
Thank you, sir. Mr. Martin, we were just about to embark on UK Forces Detention Policy and Procedures, the second topic you're here to assist us with today. And we start at paragraph 26 of your witness statement for those who have it. We've already heard that as part of a counterinsurgency operation, forces trying to combat those insurgents must have the opportunity to detain individuals. Could you just explain why and how that can happen?
Sure. So there are basically two, or in Afghanistan there were two different scenarios when detention issues may come up. The first one being during a routine patrol, which might involve soldiers patrolling around a particular village or a particular base or in a particular area. They may come into contact, potentially a firefight with insurgents, where at the end of that firefight, there may be sort of insurgents who have not been killed or injured, but may be still a threat or posing a threat to UK forces or indeed the local populace or indeed Afghan security forces.
Martin, can you slow down a little bit, please, for the shorthand writer?
My apologies, sir.
Thank you, not at all.
So those forces may have been in contact with the enemy, the Taliban, and may have had to engage in combat with them. At the end of that, there may have been insurgents who were not killed and may still pose a threat to UK armed forces, Afghan civilians or members of the Afghan security forces. And in order that that threat was removed, they would be detained for the safety of our forces and the others I have mentioned.
Okay, so that's one way
Indeed.
detention could happen. So, unexpected, at any point in a patrol or on any duties or operations, there could be contact with the enemy, and as a result of that contact, then somebody would need to be detained. So that's the first, unexpected and not planned for. And the second?
The second is what we refer to as deliberate detention operations. So these would be pre-planned, like you say, and that would involve an awful lot of intelligence background and really focusing in on the sort of high-value members of the insurgency, whether because of their rank, indeed, in the insurgency, but also because of the function they might perform. And by that I might mean they might facilitate the passage of improvised explosive devices to a variety of insurgency members, or indeed they may be IED, improvised explosive device emplacers, responsible for putting those in the ground or in hidden areas. And so their importance to the continued insurgency may have necessitated an intelligence effort to find them and then a plan to detain them to take them off the battlefield. And that was, there would be against sort of three criteria we mentioned before: the mission accomplishment, force protection, or indeed self-defence.
So both types of detention seen against that backdrop. So either mission accomplishment, and that would fall into, at least in the planning for a deliberate operation, that would be why you would, as you've described, generate the intelligence to take someone off the battlefield. Force protection, if somebody happens upon the enemy and is in contact, and then self-defence, returning fire and the like, and then detaining.
Exactly.
Just picking up on the deliberate aspect, you describe them as high-value targets. And as I understand it, what you mean and what you've explained is they are of high value to the insurgency because of their rank, so they're a leader or they're a particularly important in terms of the hierarchy, or because of their actual role. And you've described a couple of examples. So somebody who is responsible for placing IEDs, or someone who's responsible for the delivery or even the making of IEDs.
Yes, there is as you can imagine, there will be components involved in IED manufacture, and some of these components will be quite scarce or quite rare, and so being able to intercept those people is quite important then to the mission accomplishment and indeed protecting the environment around us.
And were IED facilitators and placers, were they a particular threat to UK forces in the inquiry's period of interest?
Very much so.
So those are the sorts of high-value targets that UK forces would be looking at detaining?
They were one particular type,
particular.
a significant type. There were others, but yes, they were.
I was going to say, because by definition there must have been any number of other members of the insurgency who would meet the criteria for detention.
Yes.
But the point of detention was, in the name, it was to detain them,
Yes.
to remove them from the battlefield. And then what was the intended hope? What would happen to that detainee along the process?
So there will be two functions to that. The first being what we refer to as intelligence exploitation. So through questioning, can we elicit any further intelligence from those individuals? But also, were they detained with various amounts of material, potentially laptops, documents, even the components themselves, anything that we could build a greater intelligence picture of how to perhaps target other members of that network and how to break it down over time. The second case, again, like we discussed before in terms of building that safe and secure environment in Afghanistan, is could we then help the Afghan security forces bring those individuals to prosecution and then onwards potentially to a sort of criminal detention in their justice system.
So twofold. First of all, well, I suppose, three parts to it, really. Detain the individual so they're off the battlefield and they can no longer either convey or and place IEDs. Those are the examples we're looking at. To ascertain whether there's any information or intelligence that individual has that can be useful we're dealing with UK forces, so UK forces in their ongoing counterinsurgency campaign. And that would include anything they're found with, so laptops or technical items. And then finally, hopefully, they could be prosecuted and brought to justice under the Afghan system.
Yes.
So that would be those would be the 3 points to a deliberate detention.
Yes.
So at the time we're looking at in the inquiry, mid-2010 to mid-2013, the detentions that UK forces affected, what was the context of those?
So in that context, there was a significant IED threat to UK forces, our allies, and indeed the Afghan population who may not be targeted by the insurgents, but very definitely were at risk, and indeed many were killed by IEDs. There was also a growth in the insurgency in the south, and so there was a large security threat in the overall environment.
And how was that context then important when considering the detentions?
I think, as comes later in my witness statement, you'll see that the numbers of detentions increased, and also then at the same time, as we spoke about before, the Afghan judicial and investigation sort of capacity was expanding, so their ability to put people through a judicial process was growing at the same time.
So there is a large number of individuals who are allowing and enabling the use of IEDs. The insurgency is very significant in Helmand. As a result, there are more detentions and there's more prosecutions.
Yes.
It may be obvious from what you've said and what you've described, but what would happen if these individuals were not detained?
So at times you would detain individuals, and it may be the case that when they were returned to the detention facility, intelligence may then suggest that potentially we had got the wrong individual, and so those individuals might be released by a simple case of mistaken identity. Or it might be that the Afghans themselves felt that there wasn't sufficient evidence of a judicial quality to take forward a successful prosecution, and then those individuals might be released. Or indeed, it might be the case that they were transferred to the Afghans for a judicial process, but at some point in their process, they then failed to meet that threshold for going further, and those individuals would then be released by the Afghans themselves.
So it could be that there was prosecution, ultimately, or it might be that along the way the detainee is released either because they're the wrong person or because various difficulties or safeguards in the system, whichever it may be, that person isn't ultimately prosecuted.
Yes.
If the detention had not happened in the first place and a particular high-value target was not detained by UK forces, can we assume that, in theory, they would simply go on to continue what they were doing?
I think that would be the case, yes.
And so the point of detention was very much to achieve the counterinsurgency mandate.
Exactly. And even a temporal disruption to their activity would be of benefit as well.
So the ISAF mandate is very much focused on assisting the Afghans. How did that work on the ground with either detention operations which were deliberate or those which came about because of the circumstances? We've heard a little bit about Afghan partner units.
So I'd break it into a number of different levels. At the time, UK forces were spread throughout Helmand province in particular, but they were also the Afghan National Army and the Afghan National Police, and a smaller number of counter-narcotics police. So you had a broad laydown of security forces across Helmand province. A lot of our personnel would go on joint patrols with members of the Afghan National Security Forces. And so in the first category we talked about whether there might be a contact or they might see an individual and suspect them of wrongdoing or perhaps about to emplace an IED. And so there might be that unexpected detention in partnership with the Afghan National Security Forces. In the pre-planned category, then quite often our personnel would have Afghan partner units sort of embedded within them, and they would sort of plan together and then go out and do a deliberate detention operation together.
Did the role of an Afghan partner unit stay the same throughout the period we're looking at?
No. Throughout this time, there was a progressive build of both capacity in the Afghan system, but also their capability itself. The UK Armed Forces, as you might imagine, are very highly specialised, very highly trained, very highly capable, with access to a great degree of technology and intelligence. And I think it's fair to say that the Afghan partner units were not in that position to begin with, and we were trying to build them up to be at that higher level of capability. And then also in the capacity point, their security forces were also growing in sheer numbers and mass at the same time.
So it's twofold. It's more of them, to put it colloquially,
Yep.
and to make them better at what they do.
Exactly.
And as that happened, what was the role of our personnel working with the Afghan partner units?
So a very strong role in the mentoring, in that capacity building that you mentioned. But then also there would have been more of a balance of UK forces and other ISAF forces at the time being in the lead for a deliberate detention operation. And then progressively that focus began to shift, particularly as we got towards the later years before the transition you mentioned in 2015.
And so whilst it started off that UK and ISAF forces played the primary role, as it were, as capacity and capability increased with Afghan partner units, they then began to take the lead and the UK or ISAF forces began to take a back step.
Very much so.
In terms of relevant policy, can we look at relevant ISAF or NATO policy first before moving on to UK policy, and whether or not there was a difference between the two, and if there was, what it was? But at the time, during this period, strategic and operational directions came from, I think it was the North Atlantic Council, so that's the political decision-making body of NATO.
Yes.
And then it filtered down through the operational chain of command from Commander ISAF all the way through. And that authorisation, are we back to those three things? Force protection, mission accomplishment and self-defence?
Yes.
What about rules of engagement and ISAF rules of engagement, which you touch on in paragraph 33 of your witness statement? Those three reasons are why detention was authorised. Was force permissible?
Yes. In the right circumstances.
And I was going to say, and in what circumstances would force be permissible?
So there would be, so rules of engagement are quite strictly defined, and I believe you'll be seeing Air Commodore Matthew Brisani.
We will have evidence on specific rules of engagement. So this is a broader view without descending into the detail. So
at the most basic, if there is a threat to an individual member of the armed forces, a threat to their own life, then they have the right to use force up to and including lethal force if required in the circumstance. But then also it might be that in an engagement around them where they are acting on to protect their fellows or the Afghan National Security Forces, then they would be authorised to use lethal force.
So broadly what you've described is self-defence when met with a threat?
Yes.
ISAF had a standard operating procedure, is that right, when it came to detention?
Yes.
And that dealt with how detaining forces were authorised to use force to restrain or stop a detainee escaping. And what you've just described was set out in the standing operating procedure, that deadly force was not to be used unless necessary to prevent an act constituting an immediate threat to life. And more broadly, I suppose you could summarise as you have that persons detained, there are ways in which they must be treated, and there's quite a lot of detail about this which we'll come on to, but broadly, respect and dignity.
Yes.
And in compliance with applicable international humanitarian law and human rights law.
Yes, very much so.
Where you have a partnered operation, whether that's unexpected or deliberate, who was to carry out the detention? Was there any primacy afforded to either the NATO forces or the APU forces?
So it would depend on the circumstances. When the Afghan National Security Forces were in the lead, then they would largely be responsible for the detention itself. Where ISAF forces were in the lead, it would predominantly be down to the ISAF forces. If there was an instance where ISAF thought for whatever reason there might be a risk to the detainee from either the Afghan security forces or indeed the wider populace, there may be a decision taken at the time, at the immediate time, that ISAF forces should take control of that individual to protect them as well.
In your witness statement at paragraph 36, you said this: where possible, Afghan National Security Forces, ANSF, were to be the detaining force. Why was that the hope or the aim, where possible?
So I think that goes all the way back to the UN Security Council resolutions, all the way back to December 2001. And you will see the thread through the documents of the emphasis on the government of Afghanistan. But then also embedded within the policies is the right understanding that the Afghans know best how to deal with their own population and how to deal with their own people. So where possible, both culturally and sort of nationally, it was their lead in their nation, and we actively wanted to promote that leadership where possible. Like we talked about in terms of capacity and capability, that may not have always been possible.
But because we're back to ISAF being an assistance force, primacy remaining with the Afghans themselves, detention was just another part of that, for all the reasons you've just set out, because the Afghans will be able to deal with their own civilians, not civilians, sorry, obviously, they've been detained, but their own populace, and they should be afforded primacy because you're supporting, not doing it for them.
Very much so, yes.
So the NATO standing operating procedure, did that distinguish between planned and unplanned detention operations in the way you've described?
Yes.
And what was the difference as far as the NATO standing operating procedures were concerned, if they were different to how you've described the difference here?
So there'll be a hierarchy of documents in many ways. The ISAF guidance will have been set at a relatively high level. UK detention guidance, as you will see in the exhibits, goes into a lot more detail on the operational requirements upon individuals to make absolutely clear what were the requirements and permissions for each individual when they came into these situations.
So the differences aren't because there's a difference in focus or a difference in how detainees are to be treated. It's that ISAF is at a higher level and the national documentation will descend into the detail.
Yes, and our policies were aligned with the ISAF guidance.
So I suppose it makes sense when stepping back that UK policy would be aligned with ISAF, given you're working in an ISAF structure.
Yes.
When a person was detained by an Afghan unit, there was a detention pathway, which was the Afghan detention pathway. If someone was detained by a UK force, there was a separate pathway, is that right?
Yes.
How long were detainees allowed to be held for by ISAF or UK state?
So the ISAF policy requires detainees to be held for a maximum of 96 hours from the point of detention before they should be released or indeed transferred to the Afghans for prosecution purposes. The UK took a view that in exceptional circumstances we could exceed the 96 hours in a strict and highly governed process for intelligence exploitation, or indeed where there might have been capacity issues in the Afghan system whereby they simply couldn't, they wanted to take the insurgents, the detainees, for prosecution, but they simply didn't have colloquially enough space in their detention facilities. We would then hold them until such time that we could transfer them to the Afghans.
Okay, so it's 96 hours.
Yeah.
And after 96 hours, unless there are exceptional circumstances, they either have to be released, so back into the wider population, or they're transferred to an Afghan detention pathway for ultimate prosecution.
Yes.
The 96 hours, how was that set?
Forgive me, I don't understand.
There's a period of 96 hours. It's an ISAF period of time. How was that determined? Where did it come from?
I don't know exactly where it came from, but it was laid down very early in ISAF operations, possibly going back as far as 2001, 2002. The situation then was quite different, and ISAF had quite a limited geographical role, as we outlined in the UNSCRs. But that policy endured for the time of operations.
So the 96 hours was an early period of time which was set upon for detainees detained by ISAF, but it didn't really change throughout the entire period, and that 96 hours was on the whole maintained.
Yes.
Just moving from detention to looking at how ISAF viewed compounds, because obviously we've heard already that a lot of deliberate detention operations focused on a compound. That was the point of them. So what was the policy on entry into compounds as far as ISAF were concerned? And this it starts at paragraph 38 of your witness statement.
So there was very high consideration of particularly the Afghan cultural elements, and in Afghan culture it's sort of very rude for an uninvited guest into a compound. We took these things incredibly seriously, including ISAF and in UK policy, and so you'll see in the night raids directive.
You're going to come on to.
And those sorts of considerations were to really embed in the mind that there had to be a very explicit reason for entering such a compound for value against some of the criteria we have mentioned. So again, it was to emphasise the importance of thinking carefully before conducting such an operation.
So even when planning a detention operation, at the forefront of the minds had to be just how serious it was to breach and enter into an Afghan compound because of the cultural sensitivity.
Yes, and it goes back to this was in a counterinsurgency where very much the will and the mood of the population is of vital importance, as well as respecting people's cultures and traditions.
So we've heard already about counterinsurgency, but it's the idea of engaging the population rather than alienating the population.
Yes.
Sometimes called winning hearts and minds.
Yes.
The night raids directive is your exhibit GM18, and I'm going to ask that that's brought up, please. GM18, thank you. You should have a copy in the folder that's before you. Thank you. Now, this is a NATO ISAF document. Is that right, Mr. Martin? We see at the top.
Yes, that's right.
Sorry, I'm just going to move my microphone before I knock it out of the way. And this, we'll come to see at the end, but was issued by David Petraeus, who was Commander ISAF at the time.
Yes, that's right.
It's dated the 7th of December 2010, as we see, and it's entitled Night Raids Tactical Directive. Did this set out the requirements for any night raid on a compound carried out by any ISAF force?
Very much. David Petraeus at the time was the commander of ISAF, and this will have been his guidance and what he expected from the forces under his command.
And so we see in the purpose to provide guidance and commanders' intent on the conduct of night raids by all conventional and special operations forces in Afghanistan under my command. And to be clear about that, UK Special Forces would fall into that category of persons.
Yes.
So this night raids directive applied to both conventional UK forces and to UK Special Forces.
Yes.
He then goes on to set out what the commander's intent is at paragraph 2. And he goes on to say we're in a war of perceptions. Ultimately, how the Afghan people judge our conduct and perceive our intentions will be decisive factors in their decision to support the combined Afghan and coalition effort to defeat the insurgency. Not only must we protect the people, we must also earn their respect and their support, both of which are critical to the ultimate success of the mission. So this is the counterinsurgency mission, and it's about bringing the people with you rather than alienating him, and that's set out very clearly right at the start.
Yes.
He then goes on to deal with operations conducted at night are an essential component of our campaign, with the ability both to deliver decisive effects and to reduce civilian casualties. So there is no doubt from what he's saying here that a deliberate operation at night to detain someone is extremely useful and can reduce civilian casualties, so would be preferable over some other form of activity or a kinetic strike, for example.
Again, it would be dependent on the circumstances, but yes, you would assess the nature of the operation you want to conduct, the geography or where that might be, and then make an assessment on when or how might be the best way of conducting that operation, including at night, if applicable.
And then he goes on to explain what you've just told us. However, night raids also have the potential to undermine the goodwill we're trying to achieve. Because of cultural norms and sensitivities, night raids can make Afghans feel violated and dishonoured, even when there are no injuries or damage. Further, our enemies have for some time used distortion and lies about night raids as propaganda. Even the most well-executed night raid potentially provides our enemy with an opportunity to spread misinformation. That makes it very clear, does it not, that night operations can be fraught with danger for all sorts of reasons, not just operating at night.
Yes, and it goes back to para 2A, where he talks about the perceptions.
So he goes on at paragraph C to say that night raids must be conducted with even greater care and preparation throughout Afghanistan than they have been conducted in the past. So this appears to be marking a change going forwards to say that this should be even better prepared. He describes looking at other options other than a night raid and suggests perhaps quartering off an objective and waiting till daylight with the support of the battle space owner, active participation of local leaders, but going on to say if a night raid is necessary, Afghans must be in the lead wherever possible, and we must do our best to coordinate these operations with essentially the Afghan government, ANSF, and local elders.
Yes.
So here what he's saying is that December 2010, it's the Afghan forces who must be in the lead where possible.
Where possible, yes.
And why was that? as far as you're aware, in the context of December 2010?
I think this reflects the evolution of the conflict to that point, but also, again, aiming towards that transition point where full control could be taken on by the Afghans to conduct these operations with themselves in the lead. And this is about sort of how we get on the journey to that path and to that destination.
Can we go to the next page, please? He then goes on to describe what a night raid is. So for the purposes of this directive, a night raid is any offensive operation involving entry into a compound, resident, builder or structure that occurs in the period between nautical twilight and nautical dawn. And it applies to all night entries, whether pre-planned or targets of opportunity. So this is broad in scope. It's any assault of any compound at any time between dawn and dusk.
Yes.
Dusk and dawn. And we come back to, at paragraph 3b, the partnering. This is, I think, what you were partly explaining earlier on. No one is more attuned to Afghan culture than our own Afghan partners. And so they should be included in the planning process at the earliest opportunity. In any event, ANSF must be included in all night raids. And he says must be included, but then when this is not feasible, that the concepts of operations and storyboards should highlight their absence and provide justification for unilateral action. So again, bringing this very much within Afghan partner units' control and involvement right from the start.
Yes, except when not feasible.
And when not feasible, I'm not going to ask you what those could be. I'm sure there are any number of options, but you've described capacity and capability as building through the process.
Yes.
Paragraph C, which is further down the page, thank you. Afghans first, the execution of any night raid should place our ANSF partners in the lead. They should be the first force to make contact, they should be the first force seen, and the first voices heard by the occupants of any compound entered. Then goes on to talk about soft knock. And unless it is not tactically feasible, all night raids should be initiated utilising soft knock or progressive breach procedures. So call-outs, trying to engage the occupants rather than simply going straight towards a hard knock, which is, excuse me, a kinetic entry, as it were.
Yes.
Military working dogs is paragraph E. And again, it's the balancing of what tactically or operationally is valuable, but what is particularly culturally difficult or sensitive.
Yes, and these considerations will have pervaded through the force to make sure that the operation is safe and secure for those conducting it, but also taking into account all the different considerations you're laying out.
And so military working dogs, sending a dog into a living area could be offensive to the occupants of that building.
Yes.
And so he goes on to say that military working dogs will not enter into the residential dwelling within a compound unless prior permission has been received from the CONOPS approval authority or for self-defence reasons. So it either has to be authorised or the circumstance must require it because there's an immediate threat to life.
Yes, and it reflects the value that the dogs can provide in such a dynamic situation. Again, it's taken very seriously, but they can quite literally save lives, both Afghan and British or ISAF.
Finally, military working dogs will remain muzzled at all times unless there's an operational necessity to unmuzzle. Excuse me. In any event, any dog must remain in the positive control of its handler. So what you've described, very effective, very useful, can save lives, but has to be very carefully coordinated and controlled.
Yes, indeed, and the use of the dog may indeed protect the life of the insurgent in terms of them being able to potentially disarm such an individual at times.
If we go to the next page, please. So this moves on to deal with searches, because as you've described, one of the purposes of a detention operation could be to recover items of usefulness, either value in terms of intelligence exploitation, but also, no doubt, weapons, narcotics, those types of things.
Yes, a variety of items and documentation, that sort of thing.
Again, this puts primacy on ANSF personnel. Is that right?
Yes, again, reflecting back, though, where possible, for the considerations we've discussed.
But there were some particularly hard lines when it came to searches, especially when it came to searching women and children.
Yes.
So completely inappropriate for a male to search a female.
Yes, although I think it does only as a last resort.
Only as a last resort.
At the end of the paragraph.
And so it would have to be, unless exceptional for necessity, a female searcher. Again, ANSF personnel to be in the lead where possible. And it says, particularly, the assistance of the local elder may also be solicited. Moving on to detainees. Again, sets out that if an individual is detained, either by coalition or partner forces, written notification must be provided to the most responsible individual with a targeted compound, or posted on the objective, and then there's got to be a follow-up. Not something that's done lightly, something that's very controlled, something that there are procedures in place for.
Yes.
And the same with property seizure. Paragraph H makes it clear that items taken should be receipted, unless obviously it's contraband. Sorry, I misread that. If any property is seized, regardless of its contraband nature, a list of all the items must be included. And it must include the nature and quantity of objects seized. And the receipt must be provided. So again, there are procedures in place, even in what could be a very difficult contact in a compound. There's still procedures for searches, for detainees, and for property seizure.
Yes.
And that's also the same for any property damage. And again, that must be receipted, and it must be delivered and posted. And again, there's got to be follow-up. Is that right?
Yes, and indeed there would have been a process for compensation if property were damaged inappropriately, and that would have been handled in the days following. So
if, for example, entry was effected to a compound and the door was damaged, then there would be a process. Was it called a shura?
So the shura is an Afghan term for a local council, informal or formal. Quite often, compensation claims would have been processed by the local ISAF unit that was there more permanently. A deliberate detention operation might be carried out by forces who were not in that region or locale permanently. So the ones that were would handle the compensation claims from local civilians.
So you could have a deliberate operation that's carried out by forces that are not permanently based in that area. And once they leave, then it's essentially the battle space owner who is responsible for dealing with any of the procedures that need to be carried out afterwards.
It would depend on the circumstances. Predominantly, probably yes, but that will have also included liaison with other forces where required to ensure that, not least to ensure that the claim was legitimate and justified.
Yes. Paragraph J deals with documentation and notes that the greatest disadvantage to night raids is the perception by the local population that inappropriate things happen under the concealment of darkness. It is this uncertainty and fear of the unknown that allows the insurgency to fabricate misinformation. And then it goes on to specify, accordingly, every night raid will be documented by a video and/or photographic record. Photographs will be taken of any damage, injury or death. Specifies medical care will not be delayed to photograph the scene. But it includes footage or photographs on the condition of the occupants and property, treatment of any detainees, and any sensitive site exploitation. Sensitive site exploitation, that's the recovery of documents, any
Documents,
items of,
components, fingerprints, the sort of a forensic examination of the situation.
goes on to say, once the objective is secure, commanders should strive as much as possible to take photographs of the scene as it is found post-assault. The record will include where any contraband was discovered prior to its collection. Unless required for security or other reasons of military necessity, contraband damage and casualties will not be moved by coalition and or partner forces prior to photographing. So what this is trying to do is create a record, a photographic or video record of what happened, what damage was caused, and if anybody was killed, then what positions they were in when they were killed, what was with them or not with them, and how the scene, if I would refer to it like that, how the scene appeared at that time.
That will be the intent. There may be circumstances where some individuals might have worn suicide vests. There will have been a requirement to make safe that device. So although it says photographed before they were moved, there may have been a sort of force protection requirement to ensure that any weapons or IEDs or grenades were made safe before you could capture that record like you suggest.
Because, of course, whilst the importance of the record keeping is emphasised here, we are not in a building 10 metres from here, which is a residential complex. We're in a conflict zone, and therefore operational security must come first.
Yes.
It goes on to say forces should generally avoid staging photographs unless necessary for prosecutorial purposes. A photograph of all collected contraband is insufficient. It must first be taken where the contraband is found. Staging photographs is an unusual phrase to hear when it comes to record keeping, but we'll come on to see when we get to evidence collection and the prosecution of insurgents, the Afghan judicial system had a particular requirement when it came to evidence. And what was that requirement in terms of photographs of detainees with contraband or weapons?
So very much the Afghan system very much liked to have sort of as much record as possible of the individual being linked to the item, the weapon, the contraband, or the components that they were seized with.
So forces should generally avoid staging photographs unless necessary for prosecutorial purposes. That's what that means. So in order to provide the Afghans with the evidence they required, it would be permissible to take a photograph of an insurgent with the weapons.
Yes, and again, that comes back to emphasising the Afghan primacy over time.
But what we shouldn't lose sight of is that before any of that happens, there should be a record before anything is moved, where possible.
Yes.
Photographs of the deceased. Deceased may be moved to photograph their individual features, but only after a photograph has been taken depicting their position as discovered. Obviously, again, with the caveat you've raised about force protection and operational security. And then dealing with the need for sensitivity towards females and children. Going over to the final page, please. So paragraph M. At the end of every night raid, a report of the operation will be provided to the CONOP Approval Authority and the battle space owner as soon as possible, but not later than 24 hours after returning from the mission. So this is an ISAF requirement for ISAF forces that at the end of any night raid, there must be a report, and it's got to be provided within 24 hours. And the report was to include the account of any death, injury, known or suspected civilian casualties, property seizure or damage, and post-operation mitigation. It was to be accompanied by representative photographs or video footage, and a copy of all photos and videos will be maintained by the unit. So at the end of every night raid, no matter how tired, exhausted, those responsible for the night raid would have to complete the records.
Yes, although there will have been supporting elements around at their home base who will have been able to assist with the cataloguing of items seized and those sorts of things.
Paragraph 5, compliance with the laws of armed conflict. In addition to the requirements above, I expect every participant in a night raid to comply with the laws of armed conflict. This includes providing medical care to the injured, using the minimum force necessary to achieve the mission, and avoiding death or injury to civilians and to those insurgents who've come under friendly force control. If any member of an operation, including partner forces, violates these and other principles of the laws of armed conflict, it must be reported to the CONOPS Approval Authority immediately upon the conclusion of the operation. So General Petraeus is specifying not only that, as we've heard, the law of armed conflict applies, but more than that, if there is a violation of that, then that should be reported to the CONOPS Approval Authority, so the Concept of Operations Approval Authority in ISAF immediately.
Yes.
And so that would be, as it's described, a failure to provide medical care, using more force than necessary, or an extrajudicial killing.
Yes.
And he goes on to finish with his conclusion. Ultimately, the Afghan people will decide the outcome of this conflict. Only with their support can we achieve our objectives. To that end, the use of night raids must be tactically sound and judiciously executed, and they must be as transparent as possible for the Afghan people most affected. Prior to submitting proposed night raids, the proponent should be prepared to explain why a night raid is the best option. Prior to every approval of a night raid, the approving officials should make a record of that explanation and possible alternative actions. I expect leaders at every level to carefully weigh the potential military value of each raid against the potential costs before moving forward in accordance with my guidance. And he goes on in scope to say, I direct this guidance to be briefed and explained to every soldier, sailor, airman, marine and civilian, including contractors, of the force as soon as practicable.
Yes.
And so what General Petraeus has done is set out a very detailed and careful directive from the top, which should filter all the way through down to every military personnel or civilian on the ground.
Yes.
We can leave that exhibit now, thank you.
Could I just ask one question, Mr. Martin, about this? It's entitled Night Raids Tactical Directive. What status does this document have from the Commander ISAF? It's of the very highest status, presumably.
So there will be a hierarchy of documentation.
Where are we in the hierarchy of the hierarchies?
I believe my understanding this will be at the highest, but a military colleague might be able to give a more fulsome answer.
Thank you.
So moving on to relevant UK detention policies and procedures. Next, please, Mr. Martin. It may be that, I'm just looking at the time, I'll make a start on this because it feels a little bit too early for a break, but we may break in the middle if that meets with your approval. So.
Indeed.
So in terms of setting UK detention policies and procedures, and this starts at paragraph 41 of your witness statement, how was that done?
The development of the policy, sorry.
The setting of it. So where did it come from and how was it done?
So a lot of the policy will have been evolutionary, both evolutionary in terms of a reaction to the conflict, but also an evolution in terms of our understanding of practices and what was required. So again, like where I said about a process to extend detainees beyond the 96 hours for intelligence exploitation, that was based on experience and requirements and need, but also involving a very broad stakeholder community, both in the Ministry of Defence, civilian and military at the highest level, and working its way down, but also engaging other members of the government, like the Foreign and Commonwealth Office at the time.
So a very broad base.
Yes.
In 2010, was it the Secretary of State for Defence who issued a policy statement on the strategic detention policy of the Ministry of Defence?
Yes.
So that comes from the Secretary of State.
Yes.
And in that policy was what I described as sort of the overarching humane treatment of detainees and compliance with international law. Was that set out and then essentially broken down into more detail?
Yes.
So minimum standards that must be applied for any operation. And so did that include detained persons who are held in accordance with UK procedures and laws? Obviously UK and international law, as we've discussed, and not transferring to a nation where there is a real risk of torture or serious mistreatment. And finally, ensuring procedures are in place to investigate allegations of abuse are done. Okay, so that's the strategic level. That's the overarching, those are the overarching considerations. And was it also made clear that it was the responsibility of all members of the armed forces, civil servants and contractors to inform their superiors, and also the Provost Marshal Army, the head of the Royal Military Police, if they have concerns about any element of detainee handling?
Yes.
So that reflects what we saw with Commander ISAF's directive.
Yes.
The need to report.
Yes.
Was that broad policy framework then essentially described in other documents and reduced into doctrine?
Yes. So there'll be a hierarchy of documents with that at the top.
So that sits at the top, so a bit like Commander ISAF with his directive. So the strategic policy from the Secretary of State, and that's filtered down. Was there a specific doctrine in place to deal with detainees during this period?
Yes.
And was that JDP, Joint Doctrine Publication 1-10-3?
Yes.
There's a series of those that are in place over our period. Is that right, Mr. Martin?
Yes.
And you've exhibited the stating, starting from November 2009 all the way up to the Sixth Amendment in September 2012.
Yes.
I'd like to look in a minute at three of those which show what you've already indicated, which is the evolution of policy and procedures in relation to detention and detainee handling. But before we look at the documents, perhaps you can explain to us some of the broader principles which were present in all of them. Particularly in terms of correct exercise of stop search, questioning and the like.
So at the very heart of this will be our absolute legal obligations under the laws of armed conflict, but also under UK domestic law. It will also have to include operational practice of what is feasible, what is not feasible, what is the best way of doing something versus what is a less good way of doing something, and that again fuels some of the evolution we spoke about. It'll also require sort of and particularly when we work with cross-government colleagues in terms of the policy and political dimensions at the time, and what sort of ultimately the politicians wanted to sign off and want to agree to, hence why the very top you have the statement of policy from the Secretary of State, him or herself.
The doctrine was, how was that then dissipated down to personnel? Was that by way of a standing operating instruction, an SOI?
Yes, and there is a thread all the way down and through to the very individualistic training that people will have received, both in general terms in their membership of the armed forces, but then also when they deploy to a specific theatre like Afghanistan, the thread through all the documents will inform that very specific training.
So those various amendments of the standing operating, I'm just going to call it an SOI, if that's all right, of the SOI, would retain that thread. Was it also, as you said, you said our policies were consistent with ISAF, but did it replicate ISAF grounds for detention and explain the minimum standards of treatment which applied and should have been undertaken together with record keeping and the like?
So it was aligned with ISAF, with ISAF guidance, but yes, it included the factors you've considered there.
Could I ask, please, that we start then in that case with Exhibit GM23. So this is disseminated by Permanent Joint Headquarters. We see it's SOI J39, and we see at the bottom Amendment 2 dated the 12th of April 2010. So this was the version that was in force at the start of the inquiry's period of interest. And it's entitled Stop Search, Question and Detention Operations in the Herrick Joint Operations Area. Could we go to the next page, please? There's a very long index which sets out that this is broken down into 3 parts. And if we just go to the next page, please, and onto the introduction, please. So we've got the introduction, part 1, which deals with stop search and detention, and then part 2, which is continued detention. And I just want to look at some of the details in the introduction, just so we can understand what this document said, the detail it descends to. Now, the aim of it is set out at paragraph 1, and that's to clearly outline the procedures for the correct exercise of powers of stop, search, questioning and detention by all UK troops operating in the Herrick Joint Operations Area. So the Herrick JOI, that was where UK forces were in Afghanistan, is that
Yes, right? That's correct.
And so it's all UK troops who are operating within that area.
Yes.
This supersedes the original, the version which was in force from the 6th of November 2009. It goes on to say it's divided into 3 parts, the introduction, part 1 and part 2. But can we go, please, to paragraph 5? As part of the Op Herrick mission, it may be necessary for UK personnel to stop, search, question and detain individuals. ANSF working alongside UK forces are, wherever possible, to take the lead in detention operations, and the role of UK forces should be to ensure that there is a humane, safe and secure environment in which such operations can take place, and to assist if necessary. So we see the same reflection within the UK SOI that we've seen within the ISAF.
Yes, exactly.
It goes on to say detention policy is bound by both legal and policy considerations. In conducting detention operations, commanders and staff at all levels should be aware that detention is subject to continual and external scrutiny, and that inappropriate actions today could result in legal challenges that undermine the UK's ability to conduct detention and interrogation operations, not just in Afghanistan, but in future operations. So this makes it very clear just how important detention is as a feature of military operations overseas.
Yes.
Detention principles start with detention criteria at paragraph 6. Thank you. So, authorised to conduct stop, search, detention and question procedures in accordance with reference A. But this is essentially the ISAF 3 pillars: force protection, mission accomplishments and self-defence.
Yes.
ISAF authorities authorises detention for up to a maximum of 96 hours, as you've described. This is replicated here. They either have to be released after that, or they can be handed over to the Afghans. And that's what it says in post-detention requirements. And here we go on to look at what you've described, which is those exceptional circumstances in paragraph 7. So it's 96 hours until the final paragraph, the final sentence of paragraph 7. Detainees should only ever be detained beyond 96 hours in exceptional circumstances as follows. On medical or logistic grounds, so logistic grounds, the example you gave was that there simply wasn't space within the Afghan detention facility. That would be a logistical ground.
It could, or you might also have, they might be in a location where we couldn't get a helicopter or a means of transport to that location, to the next onward one.
So there could be a number of logistic reasons.
Yes.
They would still have to be exceptional.
Yes.
With HQ ISAF authorisation.
Yes.
So it's not just whoever's responsible for the detainee making the decision, and ministerial authority where appropriate. So there are occasions when the minister themselves would need to be providing approval.
Yes.
With PGHQ and ministerial authority, so that's the second way in which detention could be authorised.
Yes.
So extension over 96 hours, quite difficult, quite a high bar.
Yes.
Minimum standards of treatment. This sets out generally respect for local and cultural, religious customs and heritage, no torture, intimidation, violence or inhumane treatment. There's 5 techniques which we'll come on to look at in detail. They're specified in a bit, but the 5 prohibited techniques must never be used. And there's always a balance between effective detention and intelligence operations with consideration of the detainee's rights.
Yes.
Can we move on, please, to its page J39-11, so page 8 in the slide. Thank you. So this is the beginning of part 1, and there's an awful lot of detail in this SOI. Would every person on deployment in Afghanistan be expected to read this?
So this would have been available, but it would not be expected that each individual would read it. But again, this would inform that thread all the way down to the very individualistic training that they would have gone through.
But this is the foundation for the training they would have gone through.
Yes.
And the training specifically for handling detainees and what to do once someone is detained.
Yes.
So in the mandate, let's start with the top actually. Although this section lays out stop, search, questioning, detention provisions in a linear manner, this will not always reflect events on the ground. So reflecting the operational reality. But notwithstanding that, where at all possible, this should be maintained.
Yes. And things may not happen in the order that are laid out.
In the order. But there are do's and don'ts.
Yes.
So the mandate is set out again, why detention can be necessary, and then responsibility for detainees. But then what can be done is set out in grounds and principles. So stop. Any member of the UK forces may stop an individual for as long as necessary to ascertain their identity, movements and the like. Going over the page, please. Search. An individual may only then be searched where they're suspected of carrying a weapon, ammunition, explosive ordnance or other military equipment, or if they're considered a risk to mission accomplishment, the call sign or wider force protection. But then again, there's procedure here. So the reason for the search has to be explained in the language of the individual, and there should be paperwork again and notice.
Yes.
Tactical questioning. So this comes back to the point of detention, so ascertaining information or intelligence. And they're set out here, and I'm not going to go through the very minute detail of all of this, but just to summarise, and if I get it wrong, I'm sure you'll tell me. But tactical questioning, the point of this is to ascertain information and intelligence, but there are rules about this. And it can only be done by qualified personnel.
Yes.
And there are rules about how it can be done. And again, when it comes to detainee treatment, that feeds very much into tactical questioning.
Yes.
So there is no difference between how a detainee is treated whilst they are being detained or when they're being questioned.
No.
In terms of detention itself, at paragraph 8, it makes it very clear again. I think this is the third time it's said in this document that detention must be necessary, and again for those 3 reasons.
Yes, it's treated very seriously.
Paragraph 10, please. Afghan National Security Force should take the lead in detention operations. The UK force element role at these times is to ensure a safe and secure environment in which the ANSF can operate. And at paragraph 12, what we've not touched upon here is the RMP and how the RMP fit into search, detention and the like. It states very clearly at paragraph 12 that there are insufficient Royal Military Police and Theatre to be present at all detention operations. But they did have a role to play in this, didn't they, Mr. Martin?
Yes, they had a role to play across the theatre, both in mentoring the Afghan police themselves, but also in terms of assisting other forces with relevant operations.
Providing advice, support where detention is going to be carried out. And it goes on to say that it must be recognised, however, that while the RMP are on hand to provide advice, situations involving stop, search, question and detention will primarily be a unit and chain of command responsibility. So RMP supporting, providing advice, but it's down to the individual person on the ground who's responsible for it.
Yes.
Paragraph 13 refers to legal and policy advice. There was help from legal and policy if needed.
Yes.
I'm going to come back to evidence when we look at evidence gathering and move on to paragraph 27, please, before we break. And that's treatment of detainees. And there's a very long list here of the do's and don'ts. And the don'ts, there are 5 don'ts, which are inviolable. The word used is, it is forbidden in respect of each of these. So no misunderstanding about this level of treatment. So stress positions, hooding, subjection to noise, deprivation of sleep, deprivation of food and drink. So when someone is detained, these 5 techniques are absolutely prohibited.
Yes.
And thereafter, there is a humane treatment and prohibited, there's a list of humane treatment and prohibited acts. It deals with transport, when someone's injured or sick, the right to medical assistance, the right to be treated properly whilst detained. Over the page, at C, use of force. UK force is in to employ the minimum force necessary to bring a detainee under control. Once under control, no further force should be used unless necessary to prevent escape or for reasons of self-defence. Lethal force may not be used to prevent escape. Lethal force can only be used to remove an imminent threat to human life.
Yes.
So, touched a little bit on order combat earlier on with Brigadier Ebel, but once someone is detained, then the only time lethal force can be used is when they then present an imminent threat to life.
Yes.
And that is, again, one of the inviolable rules of our policy, but also ISAF policy.
Yes.
Dealing with restraint may be restrained where necessary for force protection, but the following guidelines should always be adhered to. Plasticuffs. Plasticuffs specifically issued for the purpose of restraining detainees may be used, but only to the front of the body. They should be regularly checked to ensure they're not harming the detainee. So as long as they're used properly and appropriately, a detainee can be plasticuffed.
Yes.
And then it goes on to describe what are the allowable techniques, the alternative to the prescribed techniques. So search positions, so how you do that, restriction of vision, you can't use a HUD but you can use goggles, restriction of hearing may sometimes be necessary but you can't restrict vision and sound at the same time. No other sensory deprivation, and then on to record keeping. Specific details in respect of women and children. And then over the page, we just deal with children who are under 15 and children who are 15 to 18, repeating that tactical questioning can only be carried out by people who are qualified. Photographs. No photographs will be taken of any detainees unless for operational or evidential reasons. And disciplinary action will be taken against any individual who takes non-operational photographs of detainees. Protection of privacy, protection of dignity, but also the sorts of behaviour that we saw a little bit of this morning in Brigadier Ebel's evidence, which is trained to our personnel that there is no glorification of people detained.
Yes.
Finally, paragraph 31 spelled out again the duty to report abuse. There is a moral and legal responsibility for UK personnel to report any allegations of abuse or instances of witnessed abuse, which may include unexplained injuries on detainees. Reports must be submitted, and commanders are to make a judgment as to whether or not to intervene in individual cases. They may intervene in defence of others under the rules of self-defence, but they're not obliged to do so if such an intervention would put themselves or others at any additional risk of harm. And then it goes on to describe what to do if abuse of detainees by ANSF or other ISAF forces has been witnessed, and they should be taken into UK detention for their own protection. But again, when somebody is detained, and that's as soon as they are detained, all of these protections, all of these policies and procedures, they begin.
Yes.
So I'm sure the shorthand writer probably needs a breakdown. Sure, Mr. Martin does too.
Indeed. Thank you, Ms. Broom. Let's break now until 3:30, please. Thank you. Miss Broom.
Thank you. Mr. Martin, you'll be pleased to know I'm not going to ask you about every paragraph of every version of every SOI. I'd like just to touch on two of the amendments to demonstrate, I hope, what you described as the evolution of the policy. If we turn to Exhibit GM26, please. So, if we go to the next page, please. So we see this is the amendment dated the 16th of December 2011, Amendment 5. And if we go to the index, which is the next page, thanks. The yellow highlighting indicates what's being updated, is that right?
Yes.
And so we can see responsibilities have been updated, and then the treatment of detainees right down at the bottom will come back to evidential requirements. But if we go, please, to paragraph 33, which is on page 8 of the slide. In short, this is just a much longer section now, Mr. Martin, is that right?
Yes.
There are a number of different requirements which have been added. So we now have paragraph 33, which is new commanding officers' responsibilities. That wasn't in the previous version or the previous versions that we've seen. We then have ensuring the safety and security of the detainees, providing sufficient appropriate food and water, sufficient rest, oversight. The key themes are the same. Prohibited techniques, they remain the same. And as we go over the page, again, we see much more detail provided in this SOI and the amendment. And again, over the page, please, to page 10 of the slide, particularly on restriction of vision, for example, just looking at the amount of text there. Without going through it, these will be published on the website. So for anybody who wants the details, they will be there. But in short, this policy becomes more detailed and provides more assistance and more guidance, setting out more of the do's whilst retaining the don'ts.
Yes.
So when it comes to, for example, restriction of vision, whilst you can restrict vision, there's now much more information about it, all aimed, no doubt, at protection of detainee rights and dignity.
Yes, and also instructions to our personnel on how best to operate and how to keep themselves safe from any misperception that might arise.
So this is twofold, in essence. If our personnel abide by the policy and the procedures and the assistance, there'll be no problems, because it will be recognised that they will have done everything they needed to and treated a detainee properly.
Yes.
The same exercise with GM27, please. Page 3 of the slide, please, so the date. This is the version in force through to, I think, the end of our relevant period. So this 17th of September 2012, Amendment 6, this takes us up to at least the middle of 2013. There's lots that remains the same from the beginning of our time to the end of our time. And when we look at what is the same, if we just look at, for example, page 7, right at the introduction, part 1, which goes over the page, is the same. Paragraph 7, initial detention criteria. There may be the odd word different, but the bones of it remain the same.
Yes.
So I just want to find the... So if we go to page 17, which is treatment of detainees. Again, Mr. Martin, all of those duties, responsibilities, all the procedure, if if you just flick through it, they all remain the same. Nothing has been reduced. In fact, everything has become a little more onerous if you were going to look at it from that perspective.
I think I would use the word illustrative rather than onerous.
Illustrative, okay. I'll take that. There is definitely more to read, that's for sure.
Yes. And again, drawing that thread, that will then come through into the individualistic training to make it as precise as possible.
We're going to come on to something called an aid memoir in a moment, which it seems to me, if I understand it correctly, is very much part of that thread that starts right at the top and works all the way down.
Yes.
There is one aspect, it's page 22 of the slide, which was introduced in the preceding version we've just looked at, but is in this one as well. It's paragraph 40, which now deals with particular procedure on the death of a detainee and describes the difference between a detainee death in a detention facility or a detainee dying of wounds sustained on the battlefield prior to their detention, and the way in which that must be recorded and that there must be a proper audit trail. Again, noting the significance, the importance, the need for proper record keeping when anybody died in a detention facility or died on the battlefield.
Yes.
So GM28, please, which you have exhibited, Mr. Martin, page 2, which is the title page, and this is the Otto Herrick Individual Aid Memoir. I just want to go to page 52, which is the next page, please, and this is detention. What's the point of this document, please, Mr. Martin?
So, like you said before the break, the SOI is quite detailed and there's an awful lot to read. And the aid memoir is a sort of a ready reckoner, a more readable, understandable document. Again, pulling from the same thread, so this is based on the master documentation, but makes it easier for a wider variety of people across the armed forces to read and understand their responsibilities in these situations, and is also, quite frankly, sort of slightly shorter and simpler to make it more readily understandable.
So, for example, where an SOI might be read by a commander,
Yes.
this would be much more easy to digest, quicker to read for someone on the ground.
Yes, and might be more accessible. A smaller document might be sort of more prevalent across the theatre.
Might be easier to brief. It's got the key parts to it. Easier to digest.
Yes.
Again, I don't need to go through all of it, other than for you to confirm, Mr. Martin, that this contains, again, the do's and don'ts.
Yes.
And we can see right at the bottom, detainee handling do's.
Yes.
May use plaster cuffs, how you can use them, may use black tack goggles, and if we go over the page, we've got the don'ts.
Yes.
And so we've got those key parts of that thread. Don't question unless you're qualified. And then never use the prohibited techniques. And then the rules of detention. Mr. Martin, I'm going to leave detention there and turn to your final section of evidence, which deals with evidence and the collection of evidence. It's paragraph 58 of your witness statement, and one of the aspects you were asked to explain was the collection of evidence. So right back at the beginning we spoke about the point of detention, and we had to remove from the battlefield to to generate information and intelligence and to collect items of interest and value. So site-sensitive exploitation leading to the collection of evidence. And in particular, what we saw and what you gave evidence about in respect of the Night Raids Directive, the difference with the Afghan judicial system and their requirements for evidence. So fair to say then that collection of evidence was considered to be an important aspect of any investigation and possible prosecution of suspected insurgents by the Afghans?
Yes, and also for intelligence exploitation.
what was the role of UK forces, more particularly when collecting evidence? After an operation had been carried out, what would happen?
It would be quite dependent on the circumstances and the nature of the detention. Some detentions may have been carried out in the heat of a contact or a firefight, so there may be no opportunity to conduct the site-sensitive exploitation. Others might have been more measured, and there might be more of an opportunity to investigate an area. Again, a lot of this would be always very culturally sensitive of the situation in hand. In a deliberate detention operation, that might well have been sort of one of the key factors in determining that a deliberate detention operation took place. And so it would be a very firm requirement to look at, particularly for Taliban commanders who might have documentation or further intelligence that would help us defeat IED networks or other forms of the insurgency. And this might include things like fingerprinting, chemical testing. Obviously, in a more limited capacity in the scene at the time, they might be able to be carried out in a proper facility.
Can I just point chemical testing for explosives, for example?
Yes, or indeed sometimes narcotics, if that were relevant. But then also sort of trying to amass both evidence that would enable prosecution, but also items that might help with the intelligence picture as well.
Thank you. And given what we've seen about policy in respect of detention, the SOIs that we've been looking at also contained set policies and guidance in carrying out searches for evidence. Can we look then, please, at, I'm going to go back, I'm sorry, GM23. And it's paragraph 18, page 11. So GM23, paragraph 18, Mr. Martin. So this is what you've explained to us earlier on. Evidential requirements. The understanding of what is admissible evidence differs between the ISAF nation's legal systems and Afghan law. The Afghan criminal judicial system places significantly greater emphasis on the provision of physical evidence, and every effort, therefore, should be made to secure physical evidence as part of the detention procedure. This should be reinforced with photographic evidence and witness statements wherever possible. It should be noted, however, that where such evidence is unavailable or cannot be secured, detention can be authorised on the basis of force protection, mission accomplishment and self-defence, so tying in the detention. But that making it very clear that there's a difference between what the UK system would require for evidence and what the Afghan system requires, or what another ISAF partner, another ISAF force nations. Yeah. It then goes on to set out evidence collection. In order to maximise the opportunities to prosecute and convict those responsible for committing acts of insurgency, it is vital that as much evidence as possible is gathered at all stages of detention operations. All personnel have a role to play in the collection of evidence and ensuring that it's transferred as quickly as possible whilst maintaining the forensic integrity of any evidence they gather. And then it goes over the page, please, to set out what the minimum requirements are. So statements, so the apprehending soldier, interpreter, any local national who's observed the event, and then statements from all UK force element witnesses. So again, quite a lot of work there post an operation in order to gather statements. Service police can advise on statements writing. They can be recorded at THF.
The theatre holding facility.
Theatre holding facility, thank you. And if not possible, statements should be recorded by all personnel involved. So again, the statements are important, but they're just one part of the process because photographs are the next thing. And so a photograph at the point of detention, paragraph 2, photograph of the detainee at the point of detention with all physical evidence recovered clearly visible in the photograph. So that goes back to what we were hearing about with the night raids directive, no moving of people or items until the scene has been photographed. And then what General Petraeus referred to as staging of photographs. It's the photographing of individuals with evidence.
Yes.
Property, and we've got a list here of the type of property, mobile phones, what you do with a mobile phone, notebooks, small arms, so handguns, small weapons, cables, wires. And then I'll come back to the aid memoir in a moment, because we have the second part of the aid memoir we've looked at, deals with evidence, but the evidence chain. Conviction is more likely when physical evidence is available. Statements from all those involved must accompany the detainee. Wherever possible, all evidence is to accompany the detainee to the THF. And then where it's not possible, commanding officer IEF must be informed that evidence has been seized and or collected. So the idea is that the detainee goes with the evidence package.
Yes.
And so the Afghan, whoever's going to take over responsibility for the detainee and whoever's going to take over responsibility for any prosecution has everything they need as soon as possible.
And where possible.
And where possible.
It may be a requirement to analyse a particular piece of evidence at another location.
And so that may then have to follow later.
Yes.
But all of this has to be seen in the context of what is possible at the end of every operation, as you've already set out. As with the detention aspects of policy, what we see as we go through the updates are that the evidential requirements change. Is that right, Mr. Martin?
Yes, sir. And again, back to the evolution of understanding.
Bear with me a moment. And so by the time we get to Exhibit GM27, please, on page 14 of the slide. So this is Amendment 6, 17th of September 2012, so the last one in our period. We've got a bit more information about evidential requirements. I'll just wait for you to...
Sorry.
No, not at all. So part of the difference that has evolved during the couple of years since the first version we were considering is partway down paragraph 23. Exploitation, and it's dealing with handling of evidence, but exploitation is an intelligence collection activity and not a criminal investigative process. So what's happening at the end of an operation is the site-sensitive exploitation, intelligence collection, but it's not the same as an investigative process. And so material that's seized with the detainee goes on to, say, can significantly help with the exploitation process. Raw product from interrogation sessions does not constitute evidence. So there's a much more detail about what would and would not constitute evidence. So from someone who's been interrogated without a statement, that wouldn't be of any value to the Afghan prosecution. Is that what that means?
It might give start points for their investigation.
But it wouldn't allow prosecution.
Yes.
And so, as we feed on, should a detainee confess to criminal activity, a signed statement can be produced by the detainee in the presence of any number of individuals. I think those are all Afghan officers, yes. Or...
In that sentence, yes.
Yes. So, APSS...
The Afghan Prosecution and Support Section.
And NDS, National Director of Security...
Yes, a sort of FBI equivalent.
LO Liaison Officer?
Yes, that's right.
Or in his absence, an officer from the National Director of Security in LKJ, is that Lashkar?
That is, yes.
And then we've got where further advice can be sought. So it's not enough if someone confesses. In short, you need a statement, no matter whether it's been said to someone who interrogated them.
Yes.
We go over the page, please, to page 15, and just looking at photographs. And this has been amended slightly to assist again with how to make use of any photographs which are taken. Photographs of all physical items discovered in situ and as found. These photographs must be clear and unobstructive to demonstrate their location to the place they are found. Specifies take a broad picture of the area with the item in it, and then a close-up of the item itself. Only if the items recovered are or have been seen in the detainee's physical possession should another photograph be taken of the detainee with the items. So changing the focus slightly and making it clearer what is and is not acceptable in terms of photographing.
Yes.
If we turn back to our Op Herrick individual aid memoir, and it's page 54 within the document, it starts evidence collection. Sorry, it's GM28, and it's page 4 in the slide. Sorry, page 5 in the slide. Page 54 on the internal pagination. So this is the aid memoir for evidence, which is in the same document as the detention aid memoir. In fact, it follows on. And again, those perhaps easiest to digest key points recorded here. So right at the top, only collect evidence if it's safe to do so. Don't put yourself or anybody else at risk. Obviously, that must be primary. But thereafter, we've got wearing gloves, not overhandling the evidence, of course not to contaminate it, where it's found, what's recovered, the operation name, the circumstances of its recovery, the name of the person recovering it. So this will establish continuity of the evidence. Photographing, recording details, labels, smells, texture, contents, all of that which will assist going forwards. Over the next page, please. Always wear gloves. Try not to put your DNA on things. These are all very sensible pieces of guidance when recovering evidence. But compound clearance. Bomb-making equipment will not be obvious. Collect anything suspicious, and it gives a list of things which might help. Not an exhaustive list. But at the bottom, Afghans can own AK rifles. If you find one, it does not automatically mean that he is a member of the Taliban. So Afghans, for their own protection, would have AK rifles.
Yes, it was a legal. They were legally allowed to.
They were legally allowed to do so. And so what this is making clear to anybody who's searching a compound is that the presence of a rifle on its own does not mean that they're a member of the insurgency, and that's a note of caution.
Not in and of itself.
Yeah.
Obviously, other factors will have pertained.
Obviously, I mean, if there's other evidence which suggests
Other
they
evidence.
are, then
Evidence, activity, all the indicators, indeed the prior intelligence that might have led you to that compound in the first place,
yes.
might then be suggestive.
But just that note of caution about jumping to conclusions.
Yes, exactly.
If we go over the page to page 56, please. Deploying, ensuring that you're carrying the right equipment. Don't tamper with the evidence. If you've not carried out the correct procedure, your fingerprints and DNA will be on the devices, and that could lead to problems for the person leaving their DNA and fingerprints. And then the last page, please. Dealing with how to take fingerprints, DNA, and how to photograph. And making sure that there are enough details in the photograph of identifying features, making sure they're clear, and photographing the results of the X-ray test, for example. That's the explosive test.
Yes.
Thank you. That's where we can leave the exhibits. In terms of evidence gathering and site-sensitive exploitation, there was guidance, wasn't there, in fact, doctrine on how that should be factored into the planning of any operation. So before even embarking on the evidence gathering and the SSE at the end, it should be figured in right at the start. Because if we go back to where we started, which was the two types of detention, the unexpected that just happens, or the deliberate, which is an operation to detain a high-value target and to gather the intelligence, the information, or the evidence, you've got to do it right at the beginning to make sure that when you get there, you can achieve the outcome of the mission, of the object, of the operation, which is to do that.
Yes, again, where possible. You may plan for it, but the dynamic situation on the ground may mean that you cannot fulfil that task.
Of course, and with anything, the best laid plans may not come to fruition.
Yes.
But the requirement is to think about it at the start.
Yes.
Rather than just to happen upon it at the end.
Yes.
Mr. Martin, those are the three topics that you were asked about. You were asked about one final topic, which you can assist us with a little bit, prosecution. But in fact, there are other departments that are going to be asked to deal with this because you weren't able to assist on the details of the Afghan prosecution system. But you were able to explain at paragraph 68 of your witness statement that prosecution of suspected insurgents was considered to be an Afghan sovereign matter, which you said right at the beginning, and all prosecutions were undertaken by the appropriate Afghan authorities. In terms of liaison with the relevant Afghan prosecution authorities, who led on that?
I understood largely the Royal Military Police.
The RMP led on that. Would they share a summary of any evidence obtained by UK forces, and then it was over to the Afghans to decide whether or not they wanted to take that further?
It would be quite a dynamic process, as we looked about in the previous exhibit, where you had sort of Afghan liaison officers at the theatre holding facility. There would be a conversation in terms of what they might require and what was useful and what was not.
Okay. You also raised one final matter dealing with detention, which is once a detainee was transferred to Afghan custody, having been in ISAF custody, the UK established a separate assurance process. It's in the SOI at times, but we haven't touched upon it. But was that the detention oversight team?
Yes, that was.
And that was to ensure that any detainee transferred to the custody of the Afghan authorities would not be mistreated.
Yes.
So another step in the process.
Yes.
Not just our own policies and procedures for when we have detained an individual, but on following through, oversight by the UK of Afghan detention.
As far as possible.
As far as possible, of course. Are you able to assist us with when the detention oversight team was established?
It was during the course of 2010.
2010.
Yes.
Thank you very much, Mr. Martin.
Thank you.
Just one further question from me, Mr. Martin. With Ms. Broom's help, you've taken us through a great deal of impressive documentation, which has included philosophy and doctrine, value and standards, policy and procedures, and the various hierarchies. As you said yourself, it's quite a lot to read. The aide-memoire that you showed us in relation to detention was a distillation of that. Is there a similar distillation or laminated sheet which encapsulates some of the basic principles that's available or was available to all levels?
I'd need to go away and check. I can't answer that right now. Although what I would emphasise, again, the training will have been repetitive and continued, so the principles will have been sort of embedded into personnel as they go through both general training and then the specific pre-Afghan training as well. But I will check on your request.
Thank you. Well, can I thank you very much for coming to give your evidence and for being very helpful in relation to all this very useful material. That concludes your evidence. Can I thank Ms. Broom? And that concludes the proceedings for today, I think.
It does, thank you.
Thank you both. We'll now adjourn, please, until 10 o'clock tomorrow morning. Thank you very much indeed.